Thank you, Mr. Speaker. Tēnā koutou katoa. I'm pleased to stand for the Greens this evening in support of this bill. It's a relatively small change being proposed to what's a very substantial piece of legislation, but nevertheless it does affect a very useful and positive change to the Act as it stands. It's interesting that the words appropriate and necessary are once again at the heart of a discussion about provisions within the RMA, because those who know the history of this bill will know that indeed this debate was had as long ago as 1990, when the bill was still in its draft form. Clearly the notion of appropriateness is a very relative term. It's to do with something that might be suitable or proper within a context of a particular situation, where clearly the word necessary, indicates something that needs to be done, that must be done, and indeed is prerequisite. And in 1990, the Select Committee on the Resource Management Act reported to Parliament and considered evidence that indicated that submitters to the bill expressed concern that some of the terminology in use at that time in the Old Town and Country Planning Act was being abandoned in the new legislation, and indeed suggested that the committee at the time agreed that existing wording should be used where it was compatible with the policy interest of the bill. In some cases, this is quoting from the Select Committee at the time, the committee said that in some cases the recommendation was to return to existing wording, and particularly in coastal management, and went on to say it thought it important to return to the term unnecessary subdivision use and development in place of inappropriate subdivision use and development. And the question of how different our development patterns and indeed the outcomes we witness day by day might have been had the bar been set at necessary rather than appropriate is now only a course of academic interest, but nevertheless it does highlight that the bar perhaps was set too low and that necessity indeed is an appropriate and a proper level, and this bill provides an opportunity to tighten up on at least one aspect of resource management in an area where there is now an opportunity to effect some positive change and some improvement. We note that the Technical Advisory Group report to the Minister for Environment in February 2009 recommended that requiring authorities no longer make decisions on their own designations, but that the relevant Council recommendation be the decision on any proposal. And the TAG noted that giving authorities power to make decisions on their own behalf may have had some, at least theoretical, justification when the authorities were Crown agencies, that given that so many of the authorities now are increasingly likely to be private entities, that justification is very hard to uphold. And the Greens would have been very happy to support that notion, and we would hope that it would come back perhaps later in the context of the Phase 2 reform. More specifically to this bill, there are at least two very clear and vivid examples of why the term, the reference to public interest ought to be inserted into the bill in this context. One of those has been referenced by the proposer of the bill, Ms Dyson, who noted the Central Plains Water Limited application, their successful application to become a requiring authority in order to facilitate the taking of water from the Waimakariri and the Rakai rivers and storage for later use of that water in intensive dairying. It's inconceivable that that application would meet any reasonable test of being in the public interest. To the contrary, the proposed scheme, which is still bogged in litigation, and long may it be, was intended to facilitate the development of intensive dairying in a dry area. While it might provide some useful, some positive economic spin-off, the social, environmental and indeed economic cost would far outweigh such benefit. And clearly the second example of a very poorly judged approval must be that of Riverstone Holding, who remarkably were given requiring authority status to construct the monorail through conservation land as part of a tourist link from Queenstown to Te Anau. That venture cannot possibly be seen to be in the public interest. It is a purely commercial proposition, scarcely a railway, which would be appropriate, but clearly it would not meet a public interest review. So these examples illustrate why this bill is timely, it's well conceived, it deserves and indeed will enjoy the support of the Greens. Kia ora.